Good morning. Am I loud and clear?
Recording in progress.
Good morning, Chair.
Bazaro,
Are we well?
No, I'm good. And yourself?
I'm just trying to overcome my challenges, you know. It's
Yeah. No,
it's a hell of a nightmare.
I'm with you. I'm with you on that one. In fact, I'm worried how you cope.
Yeah, no.
But
I should reapply for everything, you know.
Yes.
And the queues, even in the banks, don't help anymore. The queues in the banks are long.
Then it's quite.
On the process, the chief, are we going to take the bills together, or are we going to take them one by one?
We'll start first with the economic transport regulation.
Okay.
Then get the legal advice, then get the C list, and then go to the other two.
Okay.
You're right, Ambassador.
I have declarations only on the transport regulation bill and the economic regulation bill there.
Okay, Ambassador.
I don't know what other two you're talking about.
Or traffic and then transport.
Yeah, okay.
This road traffic amendment bill, the National Land Transport Amendment Bill, and then the economic transport regulation. Those are the three that we are dealing with today.
Okay. But there's declarations on two only.
No. Today, we're only dealing with we're only dealing with the. Let me just check. I'll check the transport. Let me check. I'll come back to you. I just want to check how's today's program.
Okay.
Fine. Thank you. Is the whip party out now? Sibela?
Chairperson,
How are you?
I'm fine, thanks on yourself, sir.
All right.
I'm just struggling a bit with the
Morning, Chairperson. There was no whip party meeting today.
Okay, great. Then it's fine. Can maybe what Enrico can do, can just round up members. Because I get a sense that
Chairperson, you are muted.
oh yes. I needed to check whether our members coming slowly or what.
Maybe, Chairperson, I can take this opportunity just to confirm members who are on the platform now.
Okay.
So far, I've recorded 7 members. It's yourself, Honorable Mushodi, Honorable Dang, Honorable Khai, Honorable Tafin, and Honorable Boshoff, and Honorable Mamare Khan. So those are the members that are on the platform, which we do form quorum and we can proceed.
All right. Can you request Enrico just to round up Honorable Chi and also Honorable Dangsma?
Honorable Chairperson, sorry. Honorable Brauterschet is asking to be admitted, and so is Honorable Boshoff.
Okay. All right. Okay. Then on that note, let's then take this opportunity to formally open our meeting by extending a word of welcome to all our honorable members. Our guests from the Department, State Law Advice, the Parliamentary Legal Office, and also our parliamentary staff and the public at large. Today's agenda, you can just flag today's agenda, Committee Secretary.
Enrico, can you fly the agenda?
You can just make it bigger. Oh, brilliant. That's the final mandate and also the negotiating mandate. We felt that we should start with the economic regulation. That's what we thought we need to start first with. Is there any apologies that you want to table, Committee Secretary?
Chairperson, so far there's no apologies that we have received.
Thank you. Then on that basis, then probably then start first with, like I indicated, with the economic regulation, transport regulation. Members will understand that there are two areas that we'll be dealing with on the economic transport regulation. The first one relates to the advice that we sought in relation to the public hearing and also in relation to the invite for comment by the Free State Legislature. We then requested the state law, the parliamentary legal advice, give us guidance in terms of moving forward. And without any waste of time, I think the Committee Secretary will guide us in terms of who's going to give us the advice.
Thank you, Chairperson. In this process, what is going to happen is that the legal advisor, Ms. Chiloshni, she's going to take through members on the legal advice. Then thereafter, members will engage with the advice. After engaging with the advice, then we will table the C list. Then we.
Thank you. Thank you, Committee Secretary. Ms. Chiloshni, the floor is yours.
Good morning, Chairperson. Good morning to honourable members and to all on the platform this morning. Chairperson, I'm on the precinct, but the Wi-Fi, the internet seems a little bit unstable. So I do request that I just turn off my camera for purposes of going through the legal opinion, Chairperson, with your permission, if I may do so.
Permission is granted.
Thank you, Chairperson. Chairperson, so as requested, Legal Services has provided the committee with a legal opinion, which I understand was circulated to the committee. I would like to just take a moment to go through the legal opinion with members and with my colleagues. Chairperson, so we were requested to advise.
Can you write it?
Chair, I've asked the committee secretary if you could kindly assist with that. Thank you so much. So we've been, as mentioned, we've been requested to advise the committee whether there are potential risks associated with the process followed by the Free State Provincial Legislature in processing of the Economic Regulation Transport Bill. This bill was classified as a Section 76 bill. If you can just move the screen up a bit. So on the 8th of November, this committee deliberated and considered negotiating mandates on the bill. And this committee noted with concern that the Free State Provincial Legislature did not confer its mandate in respect of the bill. The provincial legislature further, as we understand it, and on instruction, did not hold public hearings in respect of the bill, which is usual for processing of Section 76 bills. The provincial legislature, however, did advertise the bill in newspapers throughout the province for public comment and input. The concern that was raised was on the part of the provincial legislature to, as we understood from the last meeting, to afford the permanent delegates an opportunity to brief the committee on the bill, and a failure to afford stakeholders and communities the opportunity to participate in public hearings on the bill. And the committee wanted to know whether this could pose legal risks. Chair, I'm going to take the committee through the legal framework. So sections 59(1)(a) and section 72(1)(a) and section 118 of the Constitution all deal with the duty of the National Assembly, the duty of the NCOP, and provincial legislatures. And what these sections say is that the National Assembly must facilitate public involvement in legislative and other processes of the Assembly and its committees. It further says that it imposes a parallel obligation on the NCOP to facilitate a consultative process with the public during lawmaking, and it places a corresponding obligation on provincial legislatures. Sections 56D and 69D of the Constitution authorize the National Assembly and the NCOP, or any of its committees, to receive petitions, to receive representations or submissions from any interested persons or institutions. In terms of the rules of the NCOP, Rule 5 of the NCOP rules stipulates that members of the public may participate in the proceedings of the council by attending sittings of the council or meetings of the council's committees, by submitting petitions to the council on any matter within the council's competence, and by responding to public or specific invitations. So you could comment in writing on bills, or you could make representations or recommendations in writing on such bills, or you could give evidence or make representations before council committees. Public participation in terms of Sub-Rule 1 must be exercised in accordance with parliamentary rules. The public has access to all official notices to members and to all documents tabled in council, subject to reasonable measures taken by the chairperson of council to regulate such access in a manner consistent with national laws. Public participation affords the public, it means that we afford the public a meaningful opportunity to participate in legislative processes because it strengthens the legitimacy of legislation in the eyes of the people. Section 42 of the Constitution and Parliament's public participation model, which was also recently referred to by the Constitutional Court in the Mohale case, found Parliament wanting insofar as the standard of public participation was facilitated. It said Parliament had a responsibility to ensure its public participation includes education. It said Parliament has a responsibility to create meaningful opportunities for public to participate in its decision-making on issues that affect them. So while Parliament has a discretion to determine the manner in which to fulfill the obligation to facilitate public involvement, the question for determination, as indicated by the various judgments of the Constitutional Court, is whether the process was reasonable. In the Doctors for Life case, the Constitutional Court set out factors to be considered in determining whether public involvement is reasonable. it said you'd have to look at the nature and the importance of the legislation. It said reasonableness also requires that appropriate account be paid to practicalities such as time and expense. Yet, the court said the saving of money and time in itself will not justify inadequate opportunities for public involvement. So in evaluating reasonableness of Parliament's conduct, the court will have regard to what Parliament itself considered to be appropriate public involvement in the light of the legislation's content, importance, and urgency. The first is the duty to provide meaningful opportunities for public participation in the lawmaking process. Second is a duty to take measures to ensure that people have the ability to take advantage of opportunities provided. Section 76 of the Constitution requires mandates from provincial legislatures. And in the context of the Doctors for Life case, the court explained that the determination of whether public participation obligation was discharged was dependent on the process and the extent of public involvement that transpired in the provinces, and as well as on the extent which the NCOP delegations were involved in the process. The Constitutional Court has repeatedly emphasized that regardless of the process Parliament chooses to adopt, it must ensure that a reasonable opportunity is afforded to members of the public, and that all interested parties know about the issues and have had an adequate say. What is clear from the Mogale judgment is that the Constitutional Court will not regard impracticalities or the cumbersome nature of the facilitation of public participation at any stage of the processing of a bill as a justification for Parliament to not have met its constitutional obligation. In Mogale, the court said, it is essential to consider the relationship between the NCOP and the provincial legislatures, as the obligation to facilitate public participation rests both on the NCOP under Section 72 of the Constitution and on provincial legislatures under Section 118 of the Constitution. The duty of the NCOP is to ensure that public submissions are gathered by each province and distributed to all other provinces so that it can be considered and debated in a national forum. If the NCOP is to rely on provincial legislatures to facilitate public involvement, it must satisfy itself that provincial legislatures have held public hearings that meet the constitutional standard. In order to do so, the NCOP needs to be aware of the process that each provincial legislature undertook to facilitate public involvement. Provincial hearings are part of the NCOP process. Any defect or shortcoming in the processes of a provincial legislature will be ascribed to the NCOP. According to our brief, there was no briefing to the Free State provincial legislature by its permanent delegate. We do understand, however, that members from the provincial legislature were present at the select committee meeting and were present during the department's presentation on the matter. We have been advised that while the provincial legislature did not hold public hearings due to time and capacity constraints, the provincial legislature did, however, advertise the bill in newspapers throughout the province, calling for public comments and inputs, but that there were no responses received in respect of the call for submissions from the public. As a result, the provincial legislature did not have any negotiating mandates. Our understanding is that the provincial legislature has indicated that they will, in these circumstances, present a final mandate with no amendments to the select committee. There is no requirement that there must be public hearings. The requirement is simply that there must be reasonable public participation. If the provincial legislature afforded the public an opportunity to comment and considered the comments received, if any, then there's been public participation. If there were no public submissions received, despite the provincial legislature having called for public comments, then the provincial legislature has fulfilled their duty. As indicated by the Court in Doctors for Life case, legislatures do have a significant measure of discretion in determining how best to fulfill their duty regarding public involvement in their processes. Although the measures may vary from case to case, a legislature must act reasonably. What is ultimately important is that the legislature has taken steps to afford the public a reasonable and meaningful opportunity to participate effectively in the law-making process. So, Chairperson and members, while there were no public submissions received, despite the provincial legislature having called for public comments, it is our view that based on the brief and information provided, that the provincial legislature has fulfilled their duty in this particular instance. Thank you, Chairperson.
Thank you, Mr. Roshni, for that update in terms of the brief that you requested the legal advice office to execute. Members, that's the advice, the input that members would want to make in relation to the advice as provided. Honorable Khai.
Thank you, Honorable Chairperson. We are learning here, Chair. Some of these things we were not aware of. Because of the practice, we thought that the practice should continue the way we understand it. Now, maybe there are two areas that I need clarity on. One is the role of the NCOP, particularly the Select Committee, with regard to the facilitation of the public involvement in the provinces. In practice, what does that mean? Should we be organizing the public hearings in various districts in a particular province? That is the first question. The second question, that whether in the absence, in fact, maybe there are three, in the absence of this man negotiating or getting submission from the public and then develop a negotiating mandate, and then finally develop final mandates as a result of the feedback from the Select Committee after having considered the final mandates from the provinces. In the absence of the submissions, that would mean then there are no negotiating mandates. And then how then do you develop the final mandates without the submissions, without the negotiating mandates? Is it taken for granted that then the bill as proposed is then supported in terms of the final mandates? So the focus will be on the proposed bill in front of the portfolio committee in the province. So I need clarity around that. Maybe the third point, Chair, would be whether this will not be setting a precedent where provinces, they just advertise and wait for the submissions. And if then there are no submissions, all that they will do will be to take the Free State approach. Just clarity on those areas, Chair. Thanks so much for the opportunity.
Thank you, Honorable Khan. Let me just check as well. Is there any other hand? Honorable Tim, what is that?
Yes, Chairperson, thank you. Honorable Khai and I seem to be on the same page on this. I was really hoping that this legal opinion would provide a solution to this issue, because it's not just this particular matter, but it's the whole It's the whole sort of ecosystem of speculation about public participation. And I think the one of the roots of it is that the Mandating Act is not specific enough. And I think, just as an aside, the Mandating Act is an act that the NCOP as a whole should have a look at and consider, I don't know, a private members bill or even executive bill that makes it very, very clear exactly what public participation is and exactly step 1, 2, 3, 4, 5 of public participation, so that this sort of thing is not left to our courts, because our courts have had various, have delivered various sets of jurisprudence on this particular issue and various levels of precedent. But I am very concerned that the issue of reasonableness, if you consider South Africa and if you consider the makeup of our society, and the access to technology and the access to the ability to submit written submissions to Parliament, I'm very concerned that in the South African context, whether it's reasonable just to expect people to participate in a written format, in a written format. And so, it comes down to law again. And I know, Chair, you're a man of laws yourself. The test of reasonableness. What is it? Who is the reasonable South African? Does the reasonable South African as a whole have access to the ability to submit written submissions? So I'm not arguing one way or the other in case to the Economic Regulation of Transport Act, but I'm just saying I still believe that this leaves the entire issue of public participation open to discussion, open to interpretation, and whenever you have discretion and interpretation in something like this, you always have some sort of a possibility for issues that have arisen in this particular case. I personally believe that procedure wasn't followed here in terms of Honourable Mashodi being able to brief the Transport Committee in the Free State. I believe that is a problem, and I do believe that in a province such as the Free State, maybe Honourable Mashodi can come in here, which is quite a sparsely populated province, in the rural areas, that has multiple municipalities, where the written submissions necessarily in the Free State were the applicable way to ensure public participation. But I think maybe Honourable Mashodi could speak to that better than I could. I just don't feel that if I were to compare it, let's say, to a province like Gauteng, which is very urban, in the majority of the province seems to be very urban and has access to the facilities of submitting written submissions, whether there it might be reasonable, but maybe, and I'm speaking under correction there, but maybe the Free State is the kind of province where public hearings would have been specific. And I think that it's a gap in our law to say that public hearings aren't specifically mandated. One way or the other, there should be a specific prescription, and I think the discretion that is allowed to the provinces is far too wide. So I just want to make those general comments. And I was quite excited when I saw this presentation of this. I thought, fantastic, this is going to pull it all together. But unfortunately, right at the end, it leaves us in exactly the position we always are in, is that there's this wide discretion, this wide, space for interpretation, and that we kind of left back in the same position. Although I really appreciate the work done on the legal opinion, and I'm sure the state legal advisor will probably kind of agree with me. And I think that we as a duty as legislators, which is, I believe, the primary function of the NCOP, is to look at the Mandating Act and look at some sort of legislation that makes this entirely 100% clear what is required of the provinces. Thank you, Chairperson.
Thanks, Chief. Back to you, Mr. Leslie.
I think I had my
Thank
hand
you.
up, Chairperson.
Oh, okay, Ambassador. The floor is yours. My apology.
Yeah, thank you very much, Chairperson. I think Comrade Khai and Honorable Pratashet has covered me by and large. What we need to do as the NCOP is to actually look at the legislation regarding public participation and the regulations there too, with regard to the NCOP itself and with regard to provinces, which will mean that we would have to look at what the NA is doing jointly and review the kind of legislation and regulations, as I said, regarding public participation. Chairperson, having said that and agreeing with both Honorable Khai and Honorable Pratashet, in this instance, the section that said in the Free State case, in this particular instance, that if they have advertised in newspapers and they received responses thereto or did not receive responses thereto, they've in fact complied. So in this instance, legally, if that section is read, then they have complied. Thank you very much, Chairperson.
Thank you, Ambassador. Back to you, Mr. Leslie.
Thank you, Chairperson. I wanted to start at the end, if that's okay, and move my way up. So, Honorable Pratashet, I wanted to say that I agree with you 100% that courts do interpret public participation, and it is left to the courts to interpret public participation because there is nothing that really guides us adequately enough. There's discretion, there's reasonableness, and it is quite hard because it's always a matter of interpretation. And unfortunately, I cannot, with a legal opinion, fix these shortcomings. And you are 100% correct, and I agree with you that as legislatures, we need to close the gap. We need to say what is acceptable and what is not acceptable, what is reasonable and what is not reasonable, so that Parliament is not found wanting, as we often are when these matters get to court. So I'm in 100% agreement with you, and you are correct. And we do need to fix this. And then with regards to Honorable Khai about setting a precedent, it's quite a difficult, it wasn't, it was more comment combined with the question, but I hear what you're saying. It's almost as if, are we going to be doing a bare minimum given circumstances? And I think that the aim should always be to try and do more as opposed to doing less. And the courts will not take kindly to us taking shortcuts, especially when we say time constraints and cost constraints. Of course, they will be taken into consideration, but the aim should always be to do more substantive public participation. The difficulty, of course, is that if you are inviting the public to comment and no comments are forthcoming, then what do you do as a province? There's that old adage about you can take the horse to the water, but you can't make it drink. So it is a difficult question, and I hear what you're saying about setting a precedent and the predicament that we may find ourselves in. But in this particular instance, there was a call for public submissions and input, and unfortunately, there was nothing that came to the fore. Regarding the absence of negotiating mandates and final mandates, that's a procedural question, so the procedural advisor can answer that question. It's not a legal question. And then, Honorable Khai, your very first question, unfortunately, I couldn't hear clearly what your first question is. So if I could please ask you for an indulgence for you to just repeat your first question to me. Thank you.
Honorable Khai.
Thanks. I don't even remember it myself. Maybe what I was asking was with regard to the question of the role of the NCOP Select Committee in terms of facilitating the public involvement. What does that mean in practice? Does it mean as a Select Committee we must organize public hearings as part of public involvement in various districts of each province? Is that what it means in practice? Because I think my reading of that particular paragraph says the issue of public involvement rests with the NCOP. That's my reading of that particular paragraph. So that's why I'm asking, what does that mean then in practice? Because it's giving us an indication that we can observe ourselves with regard to ensuring that public participation or public involvement takes place in the provinces. How do we do that? Do we practically organize these public hearings ourselves, where maybe some provinces are not organizing them? So that was my first question. So I hope it's clear now. Thanks.
What to you, Suresh?
Thank you, Chairperson. So if you look at, thank you, Honourable Khai. If you look at paragraph 19 of the legal opinion, it says that the duty of the NCOP is to ensure that public submissions are gathered by each province and distributed to all other provinces. So it's not saying that the NCOP must go and get public submissions. And the long and the short of it really is that the NCOP is the, I'm going to use the term, the mother of the provinces. So basically head and body. The provinces are the body, they must do the public participation, but the head, the NCOP, needs to ensure that these things are facilitated. So it's a hand-in-hand team approach. And where the provinces are, where the provincial legislatures are falling short, I did say in the opinion that it will ultimately end up at the door or the foot of the NCOP. So it's a hand-in-hand, it must be done together and facilitated by the NCOP. Thank you, Chair.
Thank you, Suresh, for that legal advice. I guess members are now clear. I believe that hands are legacy hands, members. We are now at a point, I believe, where we are much more clearer now in terms of the input from the parliamentary legal advice. Having said that, then let's then invite Ms. Cleoshni to table the C list, the draft C list.
So, sorry, Chairperson.
Or is that not an? Oh, I thought it was a legacy held and Honorable Pratasheth.
Chairperson, I will confess that it was a legacy hand, but I think that a question from Honourable Khai has not been answered. The state legal advisor said that in terms of the precedent of not having a negotiating mandate and proceeding directly to a final mandate would need to be answered by the procedural advisors. And I think if we can just get an answer there, because I think Honourable Khai does raise a very important issue there.
Okay.
We can't have a situation to proceed straight to final mandates. Thanks. I'm sure.
Thank you. Do we have Shamara on the platform, or maybe Pumela can help us on this? Committee Secretary?
Chairperson, Shamara, she's not in the platform, but I spoke to her. She said she's driving to the hospital, but she will log in.
Okay,
Yeah.
all right. Is there is Ms. Ngema on the platform? Maybe she can share experience with us on that.
Yes, Chairperson.
Ms. Ngema?
Greetings, Chairperson. I was quickly trying to look through the Mandating Procedures Act without thinking you will call on me. If I may come back maybe in just after 5 minutes, Chairperson, I'll look into it and have a view.
Okay. Thanks for that. Are you comfortable with that, Tim?
Chairperson, may I just propose perhaps also and also not to put Ms. Ngema in the spot, because it is a procedural question, and also to allow Ms. Ali
Shamara.
to log in. Perhaps we could go through the C list in the interim. It would allow Ms. Ali some time to log in, and then it would also not put Ms. Ngema in a difficult position to. We all have our areas. We all have our respective areas of expertise. So I just want to try and be fair to everybody. If you are in agreement, Chair, then I could take the committee through the C list in the interim.
Yes, I think members will be comfortable with that. Let's not conflate the responsibilities. Knowing quite well for sure that all of us have our areas of speciality. Let's then wait for Ms. Shamara to log in, and then we'll then come to the area. Yes, let's proceed to the draft list for now.
Thank you, Chairperson. If I can just ask that the committee secretary flight the C list. That's okay.
Enrico?
Oh. Thank you so much. Okay, so we'll start with the C list. Proposed Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure amendments to the Economic Regulation of Transport Bill B 1B of 2020. Clause 1. Chairperson, on page 6 in line 31, after the word value, we've omitted the word exist and we've substituted it with exists. Before I proceed, I do want to say, Chairperson, that many, if not all, of the proposed amendments are linguistic and stylistic, and are and have been done largely to bring the wording in accordance with the standard drafting conventions. So there are no substantive changes. There is something that I do want to alert the committee to, but I will alert the committee as and when I get there. Clause 3, on page 7, in line 54, after the word transport, to omit industry and to substitute with sector. On page 8, in line 1, after the word safety, to insert climate change. Clause 4, on page 9, in line 41, after the word infrastructure, to omit will continue and to substitute with continues. Clause 5, on page 9, in line 46, after the word agreements, to insert that relate to rail infrastructure, or facilities. Clause 8. On page 10, in line 30, after the word access, to omit applicant and to substitute with seeker. On page 10, in line 51, after the word so, to omit will and to substitute with may. Clause 9, on page 10, in line 57, after the word regulator, to omit the comma. Clause 11, on page 12, in line 37, after the word regulator, to omit the comma before the em dash. Clause 12, Chairperson, I just want to alert the committee to clause 12. So clause 12 is new in the sense that it was an error on the bill as passed. It was a typographical error. So in clause 12, we referred to the section 9. And that was the incorrect section. Section 9 has nothing to do with clause 12. It should have read section 11. So we literally are correcting it here, because if we don't, it will be incorrect. And it is clear that section 9 doesn't relate or talk to what clause deals with at all. It was a typographical error, and we're correcting it here. On page 13, in line 21, we're omitting the 9 and we're substituting it with section 11. Clause 13, on page 13, from line 25, to omit subsection 1 and to substitute with the following subsection. Each regulated entity must submit to the regulator in the prescribed manner and form: A, statistical information related to the transport facilities or services that it provides or has licensed others to provide; forecast of demand for the transport facilities or services that it provides or has licensed others to provide; development plans for the facilities it operates or has licensed others to operate, or the services that it provides or has licensed others to provide; and any material change in the control of persons it has licensed to operate facilities or provide services. Clause 28, on page 18, in line 7, after the words on the, to omit site and to substitute with website. Clause 29, on page 18, in line 47, after the word regulators, to omit operational rules and to substitute with functions. Clause 38, on page 22, in line 24, after the word accounting, to insert engineering. On page 23, in line 16, after the word act, to omit the comma. Clause 43, on page 24, from line 32, to omit subsection 3 and to substitute with the following subsection 3. Any request for research made to the regulator in terms of subsection 2 must be considered on the merits of its reasonableness and the benefits to the industry, after which the necessary funding arrangements may be made by the regulator and other interested parties. Clause 54, on page 30, in line 14, after the word subsection, to omit the number 2 and to substitute with the number 1. Clause 60, on page 33, in line 16, after the word least, to omit 5 and to substitute with 7. On page 33, in line 18, after the word least, to omit 5 and to substitute with 7. clause 69, on page 35, in line 13, after person, to omit will and to substitute with is. Schedule 1, on page 36, in line 18, after the word manner, to omit directed under section 33 or. On page 36, in line 27, after the word regulator, to omit directed under section 33 or and to substitute with as. On page 36, in line 32, after regulator, to omit by direction under section 33 or and to substitute with as. And on page 37, in line 19, after the word licensee, to omit will operate and to substitute with operates. Chairperson, those are the technical changes that we have effected to the A list. Before I leave the floor, Chair, I would like to invite my colleagues from the department and from the State Law Advisor to just let me know if there's anything that I omitted or if there's anything that they wish to add. And if they do want to do so, then they are welcome to just come in now. But if everything is in order, Chair, then I thank you.
Let's do that. Is it Mr. Chigambi or anyone from the department?
Good morning, Chairperson. Thank you for allowing us this opportunity. All is well from our side, Honorable Chair. Thank you.
Thank you, Mr. Chigambi. And then from the State Law Advice Office. Who are you working with? The State Law Advice Office?
It's Miss Raksha Haricharan from the State Law Advisor.
Okay. Is she on the platform?
Yes, Chair, she is on the platform.
Let's then give her an opportunity to
Good morning, Chair.
Morning.
Morning, Chair. My name is Yolandi van Aswegen. Thank you, Chair. Good morning to you, Chair, and the honourable members and colleagues. Chairperson, I am stepping in for Raksha this morning. She has a problem with her throat this morning, so I thought let me just introduce myself. We assisted with the C list also, and we have no further comments to add to the C list. It seems to be in order. Thank you, Chairperson.
Thank you, Ms. Aswach. I just want to make sure that Ms. Aswachen, yes, Advocate Aswachen. Thank you for that input. Members, that's the C list. Any reflection by members? Let me just check from. Can I then put the C list to the members? Those that support the C list can just do that by a show of hand, because I see that there is no any member that is taking advantage of the platform that I created for input, but like this was indicated by Advocate Tilosi, it's more technical, it's more linguistic, it's more about grammar and nothing substantive except one. Can we then invite those that are
Sorry, Chairperson.
Yes, Tim?
Sorry, I did have my hand up. Chairperson, I just want to advise that notwithstanding the technical nature of the C list, the DA in this committee is that and therefore to err on the side of caution, we are going to be voting against. Thank you, but we will indicate when you do so. Thank you, Chair.
Okay. All right. Members, that's the view from Honorable President. Are you representing? Is that the view of the province or team? Just clarity on that.
Well, Chairperson, we haven't got the final mandate yet.
Oh, okay. All right.
When we get the final mandates, then I'm forced to follow the province. This is a negotiating mandate we're discussing.
Other members, can we then invite members, those that support the C list, to do that by show of hand? Just want to. Committee Secretary.
Thank you, Chairperson.
The floor is yours, Committee Secretary.
Chairperson, the hands that I can see on the platform, I see the hand of Honorable Dango, Honorable Khai, Honorable Mushodi, Honorable Mama Rekhane, and yourself.
Thank you. Meaning that provinces support that we adopt the C list. Is that the situation?
It is, Chairperson.
Thank you. Can we then indicate that? Can we then check those that are opposed? Can members take their hands down before we move to the next? Then those that are opposed to adopting the C list, can they raise their, can they indicate that by raising their hand? Committee Secretary.
Chairperson, I see the two hands, Honorable Lond and Honorable Protakas.
Thank you, Committee Secretary. Those that are abstaining? Are you abstaining, Tim?
Oh, Chairperson, there is a hand of Honorable Boshoff. She was, maybe you can just check with her, because
Honorable Boshoff, you abstaining?
No, sorry, Chair. I couldn't unmute myself to say.
Thank you, Honorable Boshoff. So therefore, honorable members, five vote in favor, and we have 3 against, no abstention. So therefore, we are adopting the C list that will then be sent, I believe, to the province, part and parcel of the report that will be sent to the province that will inform the engagement in relation to the final mandate on this one. Thank you, honorable members. Therefore, we can then officially move to the second item on the agenda, which will be the national land.
If I may, Chairperson, before you close off, it's Singema here.
Oh, brilliant.
On the question that you asked me to assist with, I still don't see Ms. Shamara having come in, but I think just before you close, I may just provide some guidance, even though it's off the cuff, Chairperson. So we maybe just have to come back in case it's not an agreement or a same understanding from the parties that should address the issue. But generally, Chairperson, I think our answer lies in the definition of the negotiating mandate, which we find under the Mandating Procedures Act, as well as the application section 2, which indicates that this act, the Mandating Procedures Act, applies to all provincial legislatures as well as the NCOP. So, Chairperson, section 5, as well as the definition of the negotiating mandate, is basically a guidance, as I said. And the definition comes as follows. It says, it means the conferral of authority by a committee designated by a provincial legislature on its provincial delegation to the NCOP. It's a conferral of parameters for negotiation when the relevant NCOP Select Committee considers a bill after tabling and before consideration of final mandate, and it may include proposed amendments to the bill. And then Section 5 of the same Act then speaks to a guiding schedule that is attached as a format as to how a negotiating mandate may be written out. And what appears in that attached schedule is that what is clear, if there is nothing that the legislature is proposing as proposals to set out the parameters of negotiating on the bill, it says the legislature must indicate whether the committee designated by the provincial legislature votes in favor, against, or abstains from voting on the bill. And they may then place any amendments if there are any. Thus, in this instance, my view would be to say a negotiating mandate is to give grounds and parameters for what the province would require or is requesting that the NCOP and its committees consider when they are looking into the deliberations and considerations of the bill before a final position is taken. So whether the proposals are there or are not there is not necessarily an issue of requirement, but I think the main thing is that a mandate at negotiating stage must indicate the potential of the end result or the outcome, whether the province is likely to be against or in favor or support the bill. And I think in addition to what my colleague Ms. Gangen has indicated, then generally speaking, the advice as it stands, it can be concluded as they have concluded that it is believed that what was done for purposes of the negotiating mandate was sufficient. I hope I've assisted, Chairperson. Thank you.
Thank you, Ms. Ngema, for that advice. I want to go back to Team and Honorable Khai.
Thank you, Chairperson. Chairperson, where the procedural advisors, but I just think what we need to, just going forward, and I'm just speaking generalities now, we must at least ask provinces to come up with the negotiating mandate, even if it is the Limpopo legislature supports the bill. But the point is just to have it absent is I think not necessarily irregular, but it basically just breaks down the process, and it speaks to the kind of precedent and the slippery slope that we could go down, that perhaps in the 7th Parliament, we just have a whole lot of provinces who just don't give us anything. I think at least just a one-liner, it's not difficult for them to say, we support the bill, there's no conditions, it's an unconditional support, at least just to let us know and make it clear that that is a requirement of the process. That's all I want to say, Chair. Thank you.
Thank you, Honorable Bratase. Honorable Khai, are you clear?
Yes, Chair. I think the clarification by Ms. Ngema or Ngema is clear, and but Chair, I would also go along with the Honorable Tim's earlier statement that the Act currently, I think there are gray areas that need to be addressed. It may be not now, but it may be maybe in the 7th Parliament. That will also assist other committees as well, not just our committee. because there are a lot of gray areas. Sometimes you get advice maybe from the procedural officer. Now, maybe rather than having to go that route, I think the Act need to be clear with regard to these issues. For example, we've just voted for the adoption of the C list. What it doesn't, the Act doesn't tell us whether as individual in the committee you can vote for or against, even if, let's say, your province has given a negotiating mandate, but then in the discussion within the committee, taking into consideration the department's views, the legal advice views, and the Office of the Chief State Law Advisor views. And then you arrive at a position that is different from that of your province originally. So what do you do in that situation? Do you still vote for having been influenced by the discussion in the committee? So I think the law must be able to clarify that. Yeah, so because now I see Honorable team has voted against. We don't know what is the position of KZN on this issue, because it has not yet been tested, the issue of the C list, because it's left to the committee, the issue of the C list. Now, what is the position of the provinces on the C list? Their position will only be when now the consolidated bill, which will include the C list and the bill that comes from the NA, is consolidated into one. It's only then that the provinces will then give us a final mandate. But there's no clarity as to when we adopt the C list, what is the positions of the provinces? Do we have a mandate on the C list, or we vote according to our own understanding of the processes? So I think the law must clarify that aspect as well, so that we sometimes we tend to vote, even if it's Section 76, when it comes to issues of maybe clause by clause voting or C list. We sometimes members tend to vote based on their parties, not necessarily on the mandate of the provinces. But I may not blame them, because when it would deal with the clause by clause or the C list, there's no clarity in terms of what is the mandate of the province when it comes to clause by clause, what is the mandate of the provinces when it comes to the C list or the A list, yeah. So those are areas that I think they need to be clarified, even if they are clarified in terms of, I don't know if Parliament also does have regulations. I know Parliament departments, when they have a legislation, an act, they also develop regulations, which will then clarify maybe the technical aspects of the clauses of an act. Thanks, Chair. Sorry for taking.
Thank you, Honorable High, for the and team for the input. Like as we indicated, members, now we need to move to the second item on the agenda, which is for the third item on the agenda, which is the fact that now we are proceeding now to the next item.
Chairperson.
Yes, Committee Secretary.
I wanted to inform you that there is a procedural officer who just logged in representing Shamara. So maybe before we will go to the next agenda item, maybe we can give, or she can be taken through her. What is it that at least she must respond on? It's
Yes.
Miss Shaida Bowers.
Sarah Boss, we,
Good morning, Honorable Chairperson.
how are you?
I'm good, Honorable Moimang. Yourself, sir?
I'm good. There was a procedural question raised earlier on the position. What is the position in relation to within the context of the mandating Procedures Act, where there was a call for, there was an advert in relation to the bill, and there was no comment received from the public. There was no public hearing. There was no negotiating mandate. What is the situation in relation to the position of the permanent delegate in that relation, in that situation, and whether legislature can, in the absence of the comment from the public, mandate the legislature to vote in favor of the bill? There was no comment received, despite the fact that there was an advert. There was an advert issued calling for the comments from the public. I hope I've correctly captured it, Honorable Khai.
Sorry, Chair.
I was saying that I hope I've correctly captured the question, the procedural question that we captured, that we posed to the meeting.
Yes, you have, Chair. But I don't know whether, because she may not necessarily be part of the process, she may be able to understand, because we've been dealing with this maybe for quite for some time. But maybe she will also ask questions so that we can then clarify. But I think you've clarified it. But then if maybe she needs more clarity, maybe we can all come in to assist.
Okay. Over to you, Ms. Powers.
Thank you so much, Chairperson, and good morning to all honorable members and colleagues in the meeting. So the procedural question, in the absence of negotiating mandate, can the province still submit a negotiating mandate on the bill? I take it that is the procedural question. So if the province can prove that they have sent out notices and that there were definitely no inputs from the public concerning the specific bill, because we do find that in some provinces, for example, if I take the example of fishing, if we have legislation that basically is about fishing permits, regulating the fishing industry, specifically regarding the public in terms of that, you will find that some provinces are not able, because they don't have that industry prevalent in their province, they're not able to even submit. So even if they do send out for public hearings or for inputs, they won't get any. But and so we do not then require an official negotiating mandate from them to say that there were no inputs in terms of that, because what the Mandates Act does, it basically provides the format in which the mandate must come in. But what would be recommended is that the province provides a letter indicating the process that they followed, indicating that they have then received no inputs from the public as such. My view further would be that even in the absence of any submissions from the public, that committee itself is also at liberty to deliberate on the bill that they received, and if there's anything from them that could also constitute a negotiating mandate. It's just like when the select committee sits and the select committee deliberates on the bill. In addition to whatever they've received from the public, there are also other inputs that members may make to say that we also would like to add this and that and the other. But when the framework of the Mandating Procedures Act, what is valid is what comes from the public. So in this case, I should think that the provincial legislature is not able to vote in favor of the bill at the negotiating stage because they do not have anything to negotiate on from the public. They are representing that public submissions essentially, and they could then, I would say that they should abstain at this process because they would provide in writing a correspondence indicating to the select committee that this is the process we have followed. Unfortunately, we have received no public submissions on the bill, and therefore we are abstaining from the process. It would be very hard to vote in favor based on what? The question would be based on what are they voting in favor? Because that negotiating mandate is basically what they gathered from the public in terms of submissions, and they've considered that and they deliberate on that, and then as the committee they agree to the parts of it from the public that they agree with, that makes sense to them, that in terms of their understanding would take the bill further in terms of not only implementation but in terms of that policy, and then therefore they would then submit a negotiating mandate. I don't know if I'm making sense, Honorable Moimang.
Yes, you do. I must then probably then put that to the members. Put that to the members in terms of clarity. Any input, members? I think you were more clear. Sarah Bowers, on the procedural question. Like as you said, it's a matter that we continue to. We need to probably do more in terms of clarifying gray areas, so that as practices unfold, that to a larger degree emanate from the gray areas, we need to probably revisit our rules, some of the acts, so that at least there's no confusion. But thank you for that for that input. Members will then move to the next at the agenda, which is the National Road Traffic Amendment Bill, and also the National Land Transport Amendment Bill. The final, we're dealing with the final mandate and also the report, and the report of the committee on these two bills. But prior to that, there is a letter that we received from the Western Cape. Can we allow Ms. Ngema just to speak to that letter, so that at least members are able to get a sense? I think Committee Secretary can read the letter, and then from there we then give over to Ms. Ngema just to have a reflection on that. Can you read that letter, Committee Secretary?
Thank you, Chairperson. The letter is directed to you, Chairperson of the Select Committee. The letter is as follows, Chairperson. Dear Mr. Moimang, heading a response to the provincial mandates, National Land Transport and Amendment Bill, and the National Road Traffic Amendment Bill. In relation to the feedback on the negotiating mandates of the above bills that was provided by the Select Committee to provinces, the Standing Committee on Mobility wished to express our displeasure at the lack of feedback. In most instances, no reason were provided why proposed amendments were not considered or accepted. it is indeed discouraging that after embarking on an extensive public participation at enormous cost to the taxpayers, it appears that the input and comments, which is at times compiled under extreme deadlines, is completely ignored or disregarded. In the spirit of cooperative governance, it will be appreciated if you could also address the matter from your side. Yours sincerely, Mr. D. America, MPP, Chairperson of the Standing Committee on Mobility.
Thank you, Committee Secretary. That is the letter that we received, but I guess the C list that was adopted was as a result of the inputs that we received from the provincial mandates. I think, and most of the provinces, particularly in relation to the National Road Traffic Amendment Act, it's something that I suspect probably we will have to engage our colleague with, but let's get from the parliamentary legal advisors whether she's able to appreciate the concern. But from where I stand, maybe we should give it to the members just to have reflection and then we move forward. Ms. Ngema?
Greetings, Chairperson, and the members once again.
Am I throwing under the bus, or should I allow members first, or should
Chairperson, I'll be guided by you, but perhaps it would be good to allow members to reflect on it first and then maybe just indicate the process and my view and understanding as to what transpired during the processes, Chairperson, and then maybe just a concluding remark once the members have spoken on their reflection.
Yes, I think let me give you the platform first, and then because the question that I posed, because I thought clause by clause, particularly in relation to the National Road Traffic Amendment Bill, the C list was informed by the mandates that we received from provinces. Maybe we can just probably clarify that just from your understanding, because you were at the center of these two bills. Yes.
Thank you, Chairperson. Chairperson, perhaps just to broadly outline what transpired and the requirements procedurally. You are correct to have made the remarks that you have made, that what we have and what we prepared, considering from the first day when the negotiating mandates were received and the content advisor prepared the document which sort of compiled all the proposals and the submissions from the public as well that were received. And then there was responses done by myself as well as the department on each and every bill. And the documents that were prepared were actually sent prior to the meetings of the committee and then were spoken to during the meetings of the committee, where the state law advisor, myself, as well as the departmental advisor spoke on the issues in trying to give the explanation and the background of the questions that were raised and provide clarity. Thus, after those deliberations had taken place and the indications from us as to what we felt was reasonable and justified in terms of justification, legally speaking and practically speaking, as the department explained, into which find itself into the corrections and the proposal amendments by this committee, which resulted in the C list. Without that process, we would not have been able to prepare the C list on our own, because that would have meant we thumbsuck whatever information we wanted. But whatever was produced into the C list is out of the deliberations of the committee, the responses and the engagement of the proposal that came out of the negotiating mandate. And that is why today the process before the committee is that in terms of the National Road Traffic Amendment Bill, there is a D version which has come out as out of the proposed amendments that were on the C list. We would not have a D version inputting and incorporating those proposed amendments without the C list, which the C list is basically an adoption of this committee, indicating that what has been placed before us and indicated to us, we are in agreement. Because at the end of the day, like we have already pointed out, negotiating mandates are providing the parameters to find one another from all the 9 provincial legislatures and to influence one another in terms of the challenges that may be specific to that province, as national legislation must attempt to deal with issues that are faced on the ground. So the parameters of negotiating are then placed, because the NCOP is a house that takes interest of all the provincial legislatures, and as they are representatives of the whole country, that's why then this forum is better placed to look at a collective influence from the provinces, as well as a collective direction as to where to go when a matter is placed before them. And that is what transpired in respect of the National Road Traffic Amendment Bill. But in respect of the remitted bill, the National Land Transport Amendment Bill, we've already explained that as a remitted bill, its reservations, its deliberations and what the committee can do is very much restricted by law itself, and not necessarily us or the committee making a resolution to that effect. The rules of the NCOP as well as the constitution we've already explained. There is not much room that the committee can go beyond what the reservations of the president are indicating. And in fact, even though that was the case, the department and myself did try our utmost best to provide the responses, the explanations, and the clarity on the issues that the mandate had raised. Hence, Chairperson, from having heard what the letter contains, I am not certain what exactly are the shortcomings or the concerns that the letter seeks to be raising, and that the committee is supposed to be deliberating on or provide an answer. But from what is being asked, the chairperson may, once the committee has dealt with the matter and addressed, prepare maybe a response in terms of what the deliberations and the resolutions of the committee in respect of this matter would be. That would be my take, Chairperson. I thank you.
Thank you, Ms. Ngema, for that. Let's check with members whether is there any. I see Tim's hand.
Thank you, Chairperson. Chairperson, I'm just a bit at a loss as to where we are here, because my understanding is that we're at the final mandate stage of these two bills, the NLT and the NRT. And I do note from the documents that we received in the past few days that in terms of the NLT, there are mandates from the Eastern Cape, Free State, KZN, Limpopo, and Mpumalanga. But there's nothing from. So, Chairperson, I think my question is going to be: is this letter from the Western Cape legislature going to change their final mandate? And then whatever that final mandate is, then obviously the representative, Honourable Lont, will have to fall in line with that. That's my understanding. But it seems that we're missing quite a few final mandates anyway. So I'm not sure where we are now. Thanks, Chairperson.
Okay. Honourable Khalid?
Yeah, Chair, I think maybe the letter is diverting us from the task we're supposed to be, because today we're focusing on the mandates.
Thank you, Honorable Khai. I think it's correct. I think let me take I take that with Honorable Lund.
Can hear me, Chair?
Now you can continue.
Oh, no. I was saying also go along with Honorable Tim's point. I'm also confused because now this letter is diverting us from our task, because in terms of the agenda, we're supposed to be dealing with the final mandates. And also procedural, there's nothing wrong that we have done, Chair. The procedure is that we, after considering the list, whether it's a C list or whatever list, that is sent to the provinces. Now, if provinces are stronger on the issues that they've submitted in the negotiations, and they feel that they still feel stronger, it's up to them whether to in terms of their final mandates that they confer, whether they vote, they confer final mandate in support or against or abstain. So that's all. You don't write letters and say we're not happy because we're not. It was not explained why. That is not the role of the select committee. Members of legislatures are also invited to be part of these processes so that they are also aware of what is happening in these processes. Minutes are sent back to the provinces with the C list and actually the consolidated bill. I don't know what number it will be, which will also include the C list. So with other participate in the processes, even they don't write back to them and say, "Oh, your view, we didn't agree with it because of that." Why must we do it to a particular, when we don't even do it to other stakeholders who make their views on these matters? The public also participate in as part of public involvement. We don't write back to them and say, "We didn't agree with your views because of ABCD." But Chair, procedural follow all the procedures in terms of
Thank you, Honorable Khan, for that clarity. Can we then, like I indicated, we will inform by the deliberations from committee, intact with the mobility committee chair, just to express the views of the committee. Committee secretary. Can we then deal with the final mandates on the National Road Traffic Amendment Bill? I think will be yes. Let's deal with the final mandate.
Chairperson, I wanted to check with the committee first whether we read the mandate. I mean, actually, the member representing, I mean, the province read their mandate. After that, then if the province is not represented, you as the chairperson read the mandate, or then us as a staff, then we can just take you through how it is. I mean, the mandate we voted, same as we did with the negotiating mandate before we adopt the report.
I propose that you read the mandate of the provinces, if members agree on that.
Thank you, Chairperson.
Sorry, Chair, usually a member from the province will read the mandate from his or her province, but in the absence of a member from that particular province, then the chair will read the mandate. What then the committee secretary will do will be to read the report, and then we put it for a vote or for adoption.
No, it's fine. It's fine. I was doing that, taking into account the time factor that earlier on the Honorable High raised with me outside the meeting. But of course, I think let's then start with the
Sorry, Chairperson.
Honorable Tim.
I'm sorry, I'm really not trying to delay things. I'm still concerned about what I raised earlier, is that there are a couple of provinces that have not submitted mandates. Are they regarded as an abstention, or how do we deal with the non-submission unless the documents I received are outdated now?
Let's check with the committee secretary, because you are correct that the mandate, the correspondence that we received from the committee secretary was that the report will continue to be updated as the mandates are received. Can we just get a sense from the committee secretary where we are now?
Chairperson, as reflected, those are the provinces that have submitted. Maybe I will allow Dr. Clark at least to take member through.
Yes, let's do that. Dr. Clark?
Yes, thank you, Honourable Chairperson. Good morning, Honourable Members. In respect of the national, sorry, we're starting with the road transport. In respect of the National Road Traffic Amendment Bill, mandates were received from 7 provinces, Honourable Members. The Eastern Cape voted in favour of this bill. This is just a precursor, Chair, to the process that the individual delegates will go through now. But the Eastern Cape voted in favour of the bill. Free State votes in favour of the bill. Gauteng votes in favour of the National Road Traffic Amendment Bill. KwaZulu-Natal voted in support of the National Road Traffic Amendment Bill. Limpopo vote in favour of the bill. Mpumalanga vote in favour of the bill. The Northern Cape supports the bill. Northwest is yet to submit a mandate on the bill, Chairperson. Western Cape is also yet to submit a mandate on the bill, presumably in light of the correspondence that the legislature has directed to the Chairperson.
Okay. Maybe the approach what we could probably do if maybe I don't know whether we still have the because it would need a procedural aspect, procedural advice, I believe, because we need 5 provinces. I think what we could probably then do, let's allow each member to present the mandate. We'll do it alphabetically, and then once we have done that, we'll then probably deal with the procedural question as to what happens in a situation where the mandate will be received after the committee has adopted the mandate. I believe at the presentation of the report to the House, there is an opportunity to amend the report if the committee agrees on that. Maybe yes.
If I'm Chairperson, Tango, I've been trying to come in since Honourable Tim commented. From Gauteng, there is a written support from the Speaker of the House. Chairperson, I want to suggest that we take the reports as read. We've all got them. They are on record, and we can actually just deal with the final mandates as they are. Otherwise, we're going to go through every poor report, and if you're talking about time, some of us do have some problems there.
Thank you. Are you comfortable with that, Tim?
Yeah, Chairperson, let's just go through the mandates and then we can discuss My question is just from a procedural point of view, how we note the Northwest and how we note Western Cape. That's all.
Okay, no, I think we'll deal with that. Let's start with let's do it alphabetically. The National Road Traffic Amendment Bill, Eastern Cape. Honorable High.
Oh, thank you, Chair. Eastern Cape, in terms of the final mandate, there's a mandate from the Office of the Speaker. On the, can you move up the first part? Oh, yeah. To the chairperson, National Council of Provinces. Name of the bill is National Road Traffic Amendment Bill. Number of the bill B7D 20-2020. The date of deliberation.
Honorable High, maybe if you can switch the video into your audio. Honorable High, I was saying that maybe if you can switch your video.
Yeah. Maybe, Chair, it's
if you can.
The video is on. Can you see me? Switch it off.
Yes, thank you.
Oh, okay. Or maybe it's because of this basement. Yes. I'm in Parliament. Those offices in the basement, they affected the bandwidth. So the name of the bill is National Road Traffic Amendment Bill. Number of the bill is B. Or the name of the bill is National Road Traffic Amendment Bill. The number of the bill is B7D-20. Date of deliberation 27 November 2023. Vote of legislature. The provincial legislature votes in favor of the bill and mandates the Eastern Cape permanent delegate to the NCOP to vote in favor of this bill. Regards, the Speaker of the Eastern Cape Provincial Legislature, Honorable Helen Sauls-August, MPR. Thank you, Chair.
Thank you, Honorable High.
Free State.
Oh, Free State, Mashori. My apology, Honorable Member.
Thank you very much, Honorable Chairperson. Good morning. Free State Legislature, final voting mandate to the Chairperson of the National Council of Provinces. The name of the bill, National Road Traffic Amendment Bill. Number of the bill, B7D/2020. Date of deliberation, the 28th November 2023. Vote of the legislature, the Free State Legislature vote in favor of the bill, signed by the Speaker of Legislature, Honorable Sifuba, on the date of 28 November 2023. Thank you very much, Honorable Chair.
Thank you, Honorable Mashori. Haute.
To the Chairperson of the National Council of Provinces, the Honorable A. Masondo. Name of bill, National Road Traffic Amendment Bill. Number of bill, in brackets, B7D-2020, close brackets. Date of deliberation, 28th of November 2023. Vote of the legislature. The Gauteng Provincial Legislature supports the principle and detail of the bill and therefore votes in favor of the National Traffic Amendment Bill, signed by the Honorable Mekwe, the Speaker of the Gauteng Provincial Legislature, dated the 28th of November 2023. Thank you, Chair.
Thank you, Honorable Dango. KwaZulu-Natal.
Thank you, Chairperson. So the mandate reads as follows. To the Chairperson of the NCOP, name of the bill, National Road Traffic Amendment Bill, number of the bills, B7D-2020, date of deliberation, Tuesday, 28 November 2023. Vote of the Legislature. The KwaZulu-Natal Legislature met today, Tuesday, the 28th of November 2023, and agreed to mandate the KwaZulu-Natal delegation to the National Council of Provinces to support the National Traffic Amendment Bill, open parentheses, B7D-2020, and that was signed by the Honourable Ntumbeko Boyce, who's the Speaker of that legislature. Thank you.
Thank you, Honorable Tim. Limpopo.
Thanks, Honorable Chairperson. Let me read the final mandate. It was written to the chairperson of NCOP. The number of the bill. Oh, the name of the bill, National Road Amendment Bill. Number of the bill B7D 2020. Deliberated on the 24th November 2023. The province vote in favor of the bill, signed by Honorable Speaker, Honorable Mulapo, on the 27th, 2023. Thank you, Chairperson.
Thank you, Honorable Momar Khani, for presenting the Limpopo final mandate. Mpumalanga.
Thank you very much, Chair. To the Chairperson of the NCOP, Honourable N.A. Masondo. The name of the bill is the National Road Traffic Amendment Bill. The bill number is B7D/2020. Date of deliberation 28 November 2023. Vote of the legislature. The delegation representing the province of Mpumalanga in the National Council of Provinces is hereby conferred with a mandate to vote in favour of the bill. So duly signed by Honourable MC Masilela, Speaker of the Mpumalanga Provincial Legislature, dated 28/11/2023. Thank you, Chair.
Thank you, Honourable Boshoff, for presenting the mandate from the Mpumalanga Province, the Northern Cape, myself, the bill. Name of the bill, National Road Traffic Amendment Bill. The number of the bill, B7D of 2020. The Northern Cape support the National Road Traffic Amendment Bill, signed by the Speaker. Northwest. You said, what is the position of Northwest, Committee Secretary?
Northwest has not submitted a final mandate on the National Road Traffic Amendment Bill, Honourable Chair.
Thank you. And then Western Cape, Honourable Lord.
The West.
Does Honourable Lord have an indication?
No. Chairperson, like we said earlier, there's a letter written to you. Would you be able to give guidance on how to approach that then?
No. Thank you, Honourable Lord. Thank you, Honourable Members. Committee Secretary.
Thank you, Chairperson.
Let's record the final mandate from provinces.
Chairperson, the bill has been supported by 1, 2, 3, 4, 5, 6, 7 provinces.
Thank you.
So in terms of the procedure, it can go through because it's been supported by more than 6 provinces.
Okay. And then in terms of the report and the diversion, what we do in that regard?
Yes, Chairperson, the report will be adopted in the due version. I see the hand of Honourable Land, Chairperson, before you can deal with the report.
Honourable Land?
Chairperson, yeah, I just want to get clarity on the process forward from our side. I mean, you have received the communication. If you can just give guidance on that, please.
Yeah. From the negotiating mandate, the province of Western Cape supported the bill. Like as we indicated, there is most of the, if you pay attention to the content advisors report, then the department's response, then the parliamentary legal advisor. Upon close scrutiny, you'll realize that we were able to capture the comments, made some amendment in terms of concrete proposal that were made by provinces, particularly, I think, Gauteng and Western Cape. Bulk of the changes that were proposed were coming from them. So we adopt what we could probably do, I think, from my advice, let's say, because I'm going to write back to the chair, explaining to him that as far as we are concerned, the issues that were raised during the negotiating mandate were correctly responded to, adequately responded to, even effected the changes as proposed by the Western Cape. Unfortunately, the letter did not speak with specificity in terms of provision or proposals. I think it was just a general letter that did not make specific areas where they are not satisfied. But I suspect, even from yourself, having been part and parcel, you realize that the changes that were made in relation to concrete proposals that were coming both from all the provinces, but more than that, it was Gauteng and Western Cape, whose concrete proposal were also agreed to by both the department and the parliamentary legal advisor. So we'll write a letter to them, but we will also make provision. I think it's the question that I've seen in certain instances. The report, the adoption of the report, when it is tabled in the House, there will be provision for amendment to accommodate those mandates that will be coming after the report is adopted. I think that is the question that I just wanted the committee to agree on, because there has been those amendments there has been those practices where, when the report is tabled at the House, the chair will then say, "This is the report with an amendment, probably an addendum to accommodate those provinces that will be bringing giving us the mandate after the report is adopted by the House." Of course, I think it is subject to, if the committee members agree on that, there's no problem. Do we agree to that procedure? There will be an addendum to accommodate those provinces that will be bringing their final mandate. I always refer to Honorable Khai because of his experience.
Chairperson?
Yes, Tim?
Chairperson, I'm comfortable with what you've said. I think that Honourable Khai was correct. The Western Cape should have just decided, based on what they received back, either to support or not support, and should have given a final mandate. When that comes in, obviously that will then allow the Western Cape to vote accordingly with that mandate when the matter is considered by the House. And I think that's really the situation. And I suppose the Northwest will be in the same position to either support or not support, depending on their final mandate when the matter is considered in the House.
Yeah.
Thank you, Honorable Tim. Honorable Khai? Okay. Committee Secretary, can we proceed then?
Thank you, Chairperson. I will request the report to be flagged.
Yes, can you take us through the report?
Thank you, Chairperson. Committee report, a report of the Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure on the National Road Traffic Amendment Bill, B7B 2020, National Assembly, Section 76. the National Road Traffic Amendment Bill, B7P 2020 National Assembly, Section 76. The bill was passed by National Assembly, transmitted to the NCOP for concurrence, and referred to the Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure, which is the Select Committee, on 27 September 2022. The object of the bill are to amend the National Road Traffic Act 1996 so as to, among other, insert a new definition, to amend others, to provide the suspension of cancellation of registration of an examiner for driving licenses or an examiner of vehicles. If such person has been convicted of an offense listed in Schedule 1 or 2 of the Criminal Procedure Act 1977, Act number 51 of 1977, or has direct, indirect conflict of interest, to provide for the registration and grading of training centers, to further provide for the registration of manufacturers, builders, bodybuilders, importers, and manufacturers of number plates, including manufacturers of reflective sheeting for number plates, supplier of blank number plates, supplier of reflective sheeting of number plates, embossers of number plates, weigh bridge facilities, manufacturer of microdots, supplier of microdots, and microdots fitment centers. The bill further seeks to require a provincial department responsible for transport or local authority to register a driving license testing center before operating as a driving license testing center. Select committee the select committee process followed in respect of the bill. On 26 March 2023, an advert was placed in the national media calling for written submissions on the bill with deadline of 24 April 2023. The Select Committee had oral submission on the bill on 31 May 2023, and on 20 September 2023, the department addressed the Select Committee on its response to the oral and written submissions on the bill. On 15 November 2023 and 22 November 2023, the Select Committee considered the negotiating mandates on the bill as received from provinces, and on 15 November 2023 adopted the C-list agreed amendments to the bill. All provinces submitted final I think need to be changed this
7
one.
provinces.
Yeah, 7 provinces. Okay, following provinces submitted final mandates on the bill, which were considered on 29 November 2023. The final mandate were submitted as follows. Chairperson, I won't go through how they submitted because it's already been reflected on the mandates. I will go to the outcome. The outcome of the Select Committee's consideration on the bill. The Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure, having deliberated on and considered the subject of the National Road Traffic Amendment Bill, B7B 2020, National Assembly Section 76, National Assembly Section 76, referred to it and classified by GMTM as Section 76, report that it has agreed to an amended Bill 7D 2020, a report to be considered. Thank you, Chairperson.
Thank you, Secretary. I think probably just 2 areas that we need to put in the report. I think 2.2, 7 provinces submitted final mandates to the bill, but then probably under 2.3, the committee agrees to have an addendum to accommodate provinces that would have sent the final mandate. That would have sent the final mandate before the House. The report is finally adopted by the House. That is the amendment that we want to put to the report. Do members agree on that? The amendment that we are making to the report?
Agree, Chairperson.
Thank you, other members. I now put the report. Probably before that, is any engagement that members would want to make in addition to those 2 corrections and addition that I made to the report? In the absence of yes, Chair. Yes, Chair.
Sorry, earlier on, I can't know the place where I am. I thought that I was safer in Parliament than at home. So I got that. No, I've referred the Northwest to call you because she was explaining that Hlupeka refused to accept the
We can't hear Honorable
You can't hear me?
Yes.
Can you hear me?
Yes, we can hear you now.
No, I'm saying that I've just referred the PLO of Northwest because she's confirming that the mandate was submitted from Northwest, but the committee secretary refused to accept it because of some challenges with it. So I'm bringing it to your attention, Chair. Okay. Maybe it could be accommodated then in the addendum that you're referring to.
Okay. Committee Secretary, can you just take the committee on in confidence?
Chairperson, yes, Honorable Khai is correct. Chairperson, one of our role and our function is to see to it that documents that are presented before the committee are documents that are acceptable. So what happened is that Chairperson Northwest, they submitted their mandate, but they submitted the mandate on the wrong version of the bill, which is the B version. So, yes, that is the reason why we refused.
Okay. So, I like as Honorable Khai indicated, so I think what will be critical is to guide them so that they are able to take opportunity open for what the addendum, because they submitted, but we are saying that there was an error in the mandate that was submitted. I think let's record that the Northwest was given an opportunity to correct the version. I remember we had the same situation in one of our bills, Honorable Khai.
Yeah, it was a copyright, Chair. So I was going to say it was wrong for Hlupeka to decide on his own. That matter was decided by the committee that the issue of, I think it was Eastern Cape and Western Cape, to correct some technical challenges that they had with the final mandates then. So the same thing should happen here, that we decide to note the final mandate of Northwest, but that they must attend to those technical issues that they need to correct.
All right. Can you also read that mandate, Hlupeka, of Northwest?
Yes, Chairperson. I will request Advocate Clark to flight it.
I don't think I have it on email, Hlupeka.
Yeah, it's fine. Let me. Okay, let me send you quickly, because it was sent on WhatsApp.
Okay. Are you gonna send it to all the members?
Yes, Chairperson, we will send it to all the members.
Okay. But the province vote in favor, but the technical error that you are raising.
Yes, Chairperson, they vote in favor.
Okay, no, great. Let's record that, and that will give the Northwest an opportunity to correct that error, but record that the mandate was submitted, but at the same time record that it needed to be corrected, meaning that 8 provinces have submitted and 8 provinces voted in favor. But there is an area of amendment that has to be made in the mandate of Northwest. Let the report capture that, and then members then put the report to the select committee. Those members that vote in favor of the adoption of the report, can they raise their hand? Committee Secretary.
Chairperson, the following members vote in favor of the report: Honorable Khai, Honorable Dango, Honorable Mushodi, Honorable Bratathes, yourself, Chairperson, and Honorable Boshoff.
Thank you. Thank you.
And Honorable Mamara.
And Honorable Marakhane. Thank you.
Sorry, Chair, I didn't hear my name.
No, your name was captured, Honorable Boshoff. It was captured. Thank you, Honorable. Then can we then have those that are voting against raising their hand? Can members lower their hand, please? Honorable, okay. Can we then have those that are voting in favor raise their hand? Committee Secretary?
Chairperson, there's none.
Any abstention? Committee Secretary?
There's none, Chairperson.
All right, and then give us the result.
Chairperson, members who voted in favor: 1, 2, 3, 4, 5, 6, 7. 7 members voted in favor, Chairperson.
Thank you, Committee Secretary. Therefore, the report on the National Road Traffic Amendment Act is therefore duly adopted by the State Committee with provision to accommodate the addendum. Thank you. Can we then move to the National Land Transport Amendment Bill? Dr. Clark?
Yes, thank you, Honorable Chairperson. Overview. Final mandates were received from the Eastern Cape, Free State, Gauteng, KwaZulu-Natal, Limpopo, Mpumalanga, and Northwest. I will now flag the individual mandates, Honorable Chairperson, if that's in order.
Chairperson?
Yes, Committee Secretary.
I want to alert Honorable, Dr. Clark, that Northern Cape just submitted now. She must update that one. Their mandate just came in 2 minutes ago.
Thank you. Thank you.
What was okay?
Okay. I think the Dr. Clark wants to update the report. What was the mandate? I think we'll do that. Let's then flag the individual mandates. Eastern Cape.
If it can be flagged, Chair, I'm ready to.
If committee can just give me 2 seconds, I just want to pull up the mandates.
We'll do that, Dr. Clark. Eastern Cape?
No, that was KwaZulu-Natal.
Oh yeah, let's go to Eastern Cape. Province of Legends.
Let's give my twin a chance to open it.
Yeah.
Maybe Honorable Khai is a roving delegate. He goes to all provinces.
Okay. Final mandate. It's addressed to the chairperson of the National Council of Provinces.
I see the bill is the National Road Traffic Amendment Bill.
Oh, okay.
Supposed to be
it's not
land transport. Let's give Doc an opportunity.
Thank you, honourable members.
Over to you, Honourable Khai.
Okay. To the chairperson of the National Council of Provinces, the name of the bill is the National Land Transport Amendment Bill. The number of bill is B7F-16. Date of deliberation was on the 27th November 2023. A vote of the legislature. The provincial legislature votes in favor of the bill and mandates the Eastern Cape Permanent Delegate to the NCOP to vote in favor of this bill. Regards, Helen Sols August, Speaker of the Eastern Cape Provincial Legislature. Thank you, Chair.
Thank you, Honourable Khai, for presenting the final mandate of the Eastern Cape Legislature. Free State, Honourable Mushori.
Thank you very much, Honourable Chairperson. The Free State Legislature final voting mandate to the Chairperson of the National Council of Provinces, name of the bill, National Land Transport Amendment Bill, number of the bill, B7F/2016, date of deliberation, the 28th November 2023. Vote of the legislature, the Free State Legislature vote in favor of the bill, signed by the Honourable Speaker, Mayor N.B. Sifuba, on the 28th November 2023. Thank you very much, Honourable Chair.
Thank you, Honourable Mushori. Gauteng. Honourable Dango.
I unmuted myself now. Office of the Speaker, final voting mandate to the Chairperson of the National Council of Provinces, the Honourable A. Masondo. Name of bill, Land Transport Amendment Bill, bill number B7F-2016, date of deliberation, 28th of November 2023. Vote of the legislature, the Gauteng Provincial Legislature supports the principle and detail of the bill and therefore votes in favor of the National Land Transport Amendment Bill, signed by the Speaker, the Honourable Merkwe.
Thank you, Honourable Dango, for presenting Gauteng mandate, final mandate. KwaZulu-Natal.
Thank you, Chair. The final mandate reads as follows. To the Chairperson of the NCOP, the name of the bill is the National Land Transport Amendment Bill. Number of the bill is B7F 2016. Date of deliberation is Tuesday, 28 November 2023. Votes of the Legislature. The KwaZulu-Natal Legislature met today, Tuesday, the 28th of November 2023, and agreed to mandate the KwaZulu-Natal delegation to the National Council of Provinces to support the National Land Transport Amendment Bill B7F 2016, signed by the Honourable Boyce, Speaker of the Legislature, and signed on the 28th of November 2023. Thank you, Chair.
Thank you, Honourable Professor, for presenting the final mandate of the KwaZulu-Natal Provincial Legislature. Limpopo.
Thanks, Honorable Chairperson. Final voting mandate from Limpopo to the Chairperson of the NCOP. Name of the bill, National Land Transport Amendment Bill. Number of the bill is B7F 2016. Date of deliberation 24th November 2023. Vote of Legislature. The province vote in favor of the bill signed by the Honorable Speaker R.R. Mulapo on the 27/11/2023. Thank you, Chairperson.
Thank you, Honorable Mahari, for presenting the Limpopo Legislature Position Bill, final mandate of the bill. Mpumalanga.
Thank you very much, Chair. The final mandate from the Office of the Speaker to the Chairperson of the NCOP, Honourable N.A. Masondo. The name of the bill, National Land Transport Amendment Bill. The number of the bill is B7F/2016. Date of deliberation, 28 November 2023. And the vote of the Legislature is as follows. The delegation representing the province of Mpumalanga in the National Council of Provinces is hereby conferred with a mandate to vote in favor of the bill. If we can just go down, signed by the Speaker, Honourable M.C. Masalela, dated 28/11/2023. Thank you.
Thank you, Honourable Boshoff, for presenting the final mandate of the Provincial Legislature of Mpumalanga. Northern Cape.
Permit me to pull it up from my email inbox, Chair.
Thank you. The name of the bill, the National Land Transport Amendment Bill. National Land Transport Amendment Bill. Date of deliberation, 20th November 2023. The number of the bill is B7F of 2016. The position of the Legislature. The committee supports the National Land Transport Amendment Bill, B7F of 2016, signed by the Speaker, Honourable Cluster, on the 20th of November 2023. Northwest. Can you read the mandate, Committee Secretary?
Chairperson, according to the procedure, you should read the mandate. If the member is representing the province is not available.
The name of the bill is the National Land Transport Amendment Bill. Go forward. The number of the bill is B7F of 2016. The date of deliberation, the 28th November 2023. The vote of the Legislature, the Northwest Provincial Legislature votes in favor of the National Land Transport Amendment Bill. Just clarity from yourself, Committee Secretary, the error that you identified was it applicable to both mandates?
Chairperson, as you can
Yes.
see, this mandate, if we can go down, well, the House must decide because it's been signed by Mr. Matobo, Honorable Matobo, who is the chairperson of committee's designated presiding office.
Okay. And it's fine. It will be accommodated by the addendum that we said that we resolved on as a committee. Western Cape.
Honorable Chair, the Western Cape did not submit a final mandate on the bill.
The same addendum that we refer to allow the Western Cape to do that after we have responded to their letter, will be accommodated too. Thank you, honorable members. Committee Secretary, can you read the results? It's eight provinces that vote in favor.
Yes, thank you, Chairperson. 8 provinces submitted their mandate and they all voted in favor. Thank you, Chair.
Thank you. Members, can we then go to the report? Committee Secretary. Okay. Committee Secretary. Are you muted or what?
Oh, my apologies, I was muted. I was still saying that I will try to read fast because at 12 o'clock there's load shedding and also Dr. Clark area there's load shedding. Committee report. A report of the Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure on the National Land Transport Amendment Bill, B7F 2016 National Assembly, Section 76, dated 29 November. Introduction. The President of the Republic of South Africa, acting in terms of the Section 79(1) of the Constitution of the Republic of South Africa, 1996, expressed reservation about the constitutionality of the certain provisions of Clause 7 of the National Land Transport Amendment Bill, B7D 2016, Section 70 is referred to the bill back to the National Assembly for reconsideration. The National Assembly Land Transport Amendment Bill, B7F 2016 National Assembly, the bill was passed by the National Assembly, transmitted to the NCOP for concurrence, and referred to the Select Committee on Transport, Public Service and Administration, Public Works and Infrastructure, the Select Committee on 25 October 2022. The objects of the bill are to amend the National Land Transport Act 2009 to insert certain definitions and amend others, to provide for non-motorized and accessible transport, to bring the Act up to date with the developments since the implementation of the Act, to provide for certain powers of provinces to conclude contracts for public transport services, to expand the powers of the minister to make regulations, introduce safety measures, to amend other transport-related legislations, to bring into line with the Act and clarify or simplify various provisions or resolve problems that have risen since the implementation of the Act, and to provide matters connected therewith. Select Committee processes followed in respect of the bill. On 26 March 2023, advert was placed in the national media calling for written submissions on the bill with the deadline of 24 April 2023. The committee had oral submissions on the bill on 31 May 2023 and 20 September 2023. The department addressed the committee on its response to orals and written submissions on the bill. On 15 November 2023 and 22 November 2020, the Select Committee considered the negotiating mandates on the bill and received the negotiating mandates on the bill as received from provinces. On 15 November 2023, the Select Committee resolved that no proposed amendments to the bill be accepted. In deliberation, the Select Committee was guided by the Rule 209 and 210 of the Joint Rules of Parliament of the Republic of South Africa, which stipulate as follows. Referral to the Council. I hope, Chairperson, I won't go through the rules as members can see, what is stipulated.
Yes.
Then I will come to how provinces voted. 8 provinces submitted their final mandate on the bill and were considered as follows. I won't go through. We've already read those ones. Then that addendum that at least you talk about, it will be affected here.
Yes.
Yes, Chairperson. And then the outcome of the Select Committee's consideration on the bill. The Select Committee on Transport, Public Service Administration, Public Works and Infrastructure, having deliberated on and considered the subject of the National Land Transport Amendment Bill, BF 2016 National Assembly, Section 76, National Assembly, Section 76, referred to it, classified by the JTMS Section 76 bill, reports that it has agreed to the bill. Report to be considered. Thank you, Chairperson.
Thank you, Committee Secretary. Honorable members, that's the report. I put the report to the committee members. Those that vote in favor of for the adoption of the report, can they do so by using the raise your hand option? Committee Secretary.
Thank you, Chairperson. The following members are in support of the report. Chairperson, it's Honorable Khai, Honorable Dango, Honorable Brotherthest, Honorable Boshoff, Honorable Mushodi, and yourself, Chairperson. I don't see Honorable Mama Rekhane and Honorable Lont here.
Okay.
Chairperson, sorry, just an apology for an Honourable Lont. He had to step out to another appointment, so that's why he's not voting. He's not disrespecting the committee.
Thank you, team, for that. Can members lower their hands? Can members lower their hands? Those.
Before that, I want to recognize the hand of Honorable Mama Rekhane now. Yes.
Okay. All right. Those that didn't vote against, can they do so by showing their hands? Is there anyone, Committee Secretary?
There's no one, Chairperson.
Any abstention?
There's no abstention, Chairperson.
So therefore, report is duly adopted by 8 provinces, and therefore the report will be forwarded to be recommended to the House for adoption with an addendum that we've agreed to. I'm looking at the challenge that we have. Can we defer the minutes? How many minutes do we have?
No, it's 2 sets, Chairperson.
It's 2 sets.
Yes.
Can we deal with them in the 4 minutes?
Maybe we can defer it, Chairperson.
Okay, thank you. let's do that so that at least we're able to pay more attention, because I suspect the nature of the minutes. It's important that we pay more attention to that. Honorable members, let's check with the committee secretary. I believe today we have exhausted all our items except those minutes.
Yes, Chairperson.
Thank you. Members will therefore then take this opportunity to express a word of gratitude to all of you for the sterling work that we have done on the 3 bills that are on our table. It has been a marathon, but because of the support that we got from both the committee staff, from the parliamentary legal advice, from the state law advice, from the departments, we are then able to with confidence recommend our reports to the House for adoption, and that could only be done through the hard work that you have infused in. We'll only be left with the ERT, Economic Transport Regulation, which obviously it has been a marathon also. But on that note, let me again express a word of gratitude to all of you, and have a wonderful afternoon. For the meeting is adjourned. Thank you.
Thank you, Chairperson. All of the best to all the honorable members.
Thank you so much.
Thank you, Chair. Thank you, Chairperson.
Joe.
Thanks for the marathon.
Thank you. Bye-bye.
Thank you.